We were delighted to be able to present during this afternoon's Business in 22 webinar, touching on an issue that really cuts across various boundaries of the law. There are whistleblower protections that New York State has boosted up in 2022 through changes to the labor law. And in our health practice, we've been thinking about, so how do those connect up to the requirements that exist for Medicaid-funded providers? And Kat Grazios, who's here with me, an associate in our health law practice, spent some time describing what the existing standards are that providers may be accustomed to thinking about. And I spent some time stitching together the ways in which whistleblower protections, now again amplified in New York State, may affect those requirements that have been in place for some time. So Kat, let me turn it to you to provide some context about what I've just described here at a high level, and we can guide our viewers here a little bit further into what they might expect if they tune into the full webinar.
Yeah, so it's important when we talk about whistleblower protections, what are we blowing the whistle on? And so in this case, one aspect that we're talking about with Medicaid providers has to do with the compliance programs that you've got to have in concert with the Deficit Reduction Act of 2005. So this Deficit Reduction Act, or DRA 05, requires providers who receive Medicaid money amounting in $5 million or more annually to have compliance programs in place in which employees are told about the False Claims Act, about how to prevent fraud and waste in the Medicaid program, and how they can be protected via the whistleblower protections should they raise any red flags concerning their employer and Medicaid fraud and waste.
Thanks, Kat. And what I addressed in my comments was a set of amendments to the labor law under Section 740 that went into effect and it became enforceable earlier this year in January. And essentially what they do in broad form is make many more activities subject to whistleblower protections. They lower the threshold under which protections come into place. They expand the types of individuals who may be essentially able to raise whistleblower claims, that are protected under the law. And what we've been thinking about, as I noted in my earlier comment within our health law practice, one I'll note, has Kat in Albany, I'm in New York City, and we have members across the state, as well as other participants. We've been thinking about, well, what are the ways that this standard around whistleblower protections in particular affects those health law clients that we seek to support in terms of their compliance programs and the kinds of things that they might need to take a closer look at and otherwise potentially improve and strengthen by way of revisions. And so we share our information today with the intention of giving all of you some food for thought in order to determine whether, if you see it worthwhile, you can reach out to the bond attorney that you trust in order to see whether your compliance policies are as robust and up to snuff as they need to be in order to be aligned with these new and ever-evolving standards. And so it was in that spirit that we presented our comments, and once more, we're hopeful that they're helpful. Kat, let me leave it to you if you have any further comments.
No, I just want to reiterate that we're prepared to assist with any policy creation, with any compliance program establishment, get your organization up and running to be in compliance with both the federal DRA 05 requirements and the New York State specific requirements in the social services law.
Thank you, Kat.